Hello everyone, thank you for watching this video. In today's video, we will be looking into wills and probate law. Specifically, we will briefly introduce the topic of entitlement to the estate, the validity of a last will and testament. This is an introduction presentation, as each requirement for a valid will be covered in separate videos. Nevertheless, let's get into this video presentation. Please stay tuned to the next slide. Let us look at a quick illustration of the entitlement to an estate. Follow along with me. Is there a valid will? If the answer is yes, were all three requirements satisfied to make a valid will? Did the testator have mental capacity at the time of making the will? Did the testator have the requisite intention to make a will? And were the formalities of Section 9 of the Wills Act satisfied? If all three requirements were satisfied, then yes, there's a valid will. If the requirements were not satisfied, then the will is not valid. There are instances where the will may be partially valid. Is there a valid will? If there is no valid will, then the rules of intestacy will apply. If the will was valid but partially valid, then the rules of intestacy will apply. If the will was not valid, then the rules of intestacy will apply. Where the will was valid, the law of testate applies, and also where the will was partially valid, the law of testate will apply. One may ask, what is a will? Let us look at the definition of a will. A will is a document that sets out how a person, who is referred to as the testator, wants his or her property to be distributed upon death. Section 9 of the Wills Act 1837 sets out three requirements for a valid will. That is mental capacity, intention, and formalities. We will be looking at each of these requirements in a separate video, so please stay tuned and look out for the other videos covering each of these requirements in turn. Thank you for watching this video. Please continue to like, share, and subscribe for more videos.